fee from him, right? So Thursday afternoon, 5 p.m., everybody's favorite time of the week, time for TPP. Right, we've got another one recording. All right. Anyway, it's all going pear-shaped. Never mind. All right, let's get on with it. So, jumping on quickly to our first presenter. You've seen him, and I'm still twisting his arm. I'm going to try and get him into his own program, but it's a negotiation. We're seeing if we can win with him, right? But in the meantime, let's get what we can out of him. And bearing in mind he's the man with the money, he can be quite difficult and tight, but he's going to be kind to you guys. So Mitesh, our resident mortgage broker, man with the money, and possibly next in line for Rishi's job. Over to you, Mitesh.
Thank you, Dil. So I thought this time round we'll touch on a topic that's not been covered off before. It's probably not an area we've had a chat before. So I thought this time round we'll cover a subject area that's quite an interesting one. And obviously there's been a lot of interesting things happening in the market today, which I'll touch on separately. So let's kick off in terms of the slides that I've prepared. So some of you may not know who I am. So I work for a company called Our Mortgage Broker. We're a team of 8 advisors, all up and running, and we've got a wealth of experience between the 8 advisors that are there. So we've got plenty of capacity to deal with inquiries. You've got my direct mobile, email contact, and our website address. We're actually based in Bracknell, and most of us actually tend to work from home. We have advisors spread across the UK, including one advisor now in Scotland as well. So I thought let's talk about buy-to-lets, because I remembered last week we touched on let-to-buys and the different scenarios, and I just thought it'd be nice to wrap up that subject and talk about buy-to-let mortgages in more detail, and also at the same time talk about some of the changes that have happened today in the market. And I'm pretty sure most of you are aware of the fact that the Bank of England base rate is now at 1%. And in terms of what you should be aware of in the background when you're looking at buy-to-let mortgages or even residential mortgages, especially when it's time for renewing the deal or looking at new transactions. So let's touch on some of the areas that you should be aware of. So when you're trying to, let's say, buy a property for investment purposes, so if it's that's basically a buy-to-let mortgage that you're looking at, you may decide, depending on the advice you're given by an accountant. I would obviously strongly recommend that you take advice from an accountant if you're thinking of setting up an LLP structure or limited company structure or a trust structure, whatever you decide to do, rather than taking advice from a broker, because a broker is not qualified to give advice on those subjects unless they have the qualification to do so. So once you figure that out, then it's best then to approach a broker to get an idea of rates and terms. Having said that, one of the things that we do always say, and I know that my MDs always said this in the past, is that there's no harm in approaching a broker at the first instance and understanding the rate difference between a buy-to-let mortgage in a personal name and a buy-to-let mortgage in a limited company name, because there will be a difference in rates. I'm not going to go into rates today, but I just thought I'll touch on that topic. So let's look at the first area that I've put on here, which is the source of deposit. So it's quite important, and I've realized this a lot with a lot of my transactions, is that it's quite important to understand where the source of deposit for the buy-to-let mortgage transactions is coming from. So why is that important? Because of the fact that rates are changing so rapidly in today's market, especially with the announcement today. I think a lot of lenders will start increasing their rates, I'm pretty sure, quite soon. Some will start increasing tomorrow, Monday, who knows. But it leaves us in a slightly difficult position if you aren't sort of prepared in connection with the source of deposit. So what do I mean by that? If your plan is to raise capital or raise the source of deposit from another property in the background, then it's important that you've done all your legwork and your all the work that's involved in order to ensure that the source of deposit can be achieved. So for example, if you're trying to remortgage your property in the background, whether it's your residential property or your another buy-to-let property you may have in the background, if you're trying to do that as a secondary transaction, then it's better that you try and sort that out first before you look at your buy-to-let transaction in terms of the purchase transaction. So I hope that's making sense. The reason why I say that is because in order for us to secure a rate with the lender, we need to send across a full application to the lender. Now, as part of that process, just as normal due diligence, we need to ensure that the source of deposit is accounted for. So in some cases, what we realize is that the clients aren't that prepared because they're still thinking of trying to raise cash from somewhere, and it's very theoretical. The process hasn't started. And that also can be the case in the scenario that I mentioned last week in the let to buy process. So if you're trying to raise cash from the existing property to move to the other property where you're trying to live in, which is the let to buy scenario that we mentioned last time, then it's important that you maybe look at the let to buy scenario first and have an idea of where you want to move at, what's your pricing bracket in terms of your cap on the type of properties you're looking at, whether it's at 500k, 600k, and so on. So it's probably a good idea maybe to look at a transaction first to ensure that you can actually raise that deposit for whatever you're looking to buy. And in this case, obviously, we're talking about a buy-to-let purchase transaction. So I just thought I'll put that in. Obviously, there's other sources of deposits. So be part cash, part gifted deposit. It could be that you're looking at something quite quirky like a second charge, which again is an area I've not touched on before, but transactions like a second charge exist in the market. So that's quite simply where you borrow an additional amount on an existing property, and it's a new lender that sits behind your existing lender. So basically that's what a second charge is all about in a nutshell. So you'll have basically two lenders that are lending against your property, which is why it's a second charge and not a further advance. The further advance is where you try and borrow additional funds from the existing lender. So I hope that all is making sense. Hopefully it's not too much information I've shared there. The second section is the current existing mortgage and any early repayment charges. So this is in line with what I mentioned. If you're trying to remortgage a property, just be a bit mindful that if your existing deal hasn't come up for expiry, this is about properties in the background, whether it's a second home, it could be another buy-to-let in the background, or even a transaction which is in a limited company structure. Just make sure that you're aware of that, and you're aware that exactly when the fixed rate expires. So the reason why it's also there is that one of the things that I've realized is that clients sometimes don't read the paperwork that are sent across from the providers. So if, let's say, you started a transaction, let's say in the month of February, and the transaction hasn't completed until the month of October, there's a very good chance that the expiry date of the existing offer that you've been provided, then the end of the fixed rate could be in the month of, let's say, May or June. But it doesn't mean to say that you have to wait all the way to August, September, October when you actually completed, and then that's the time for you to renew the deal. So it's always be mindful that you look at your expiry date, and normally it's still no annual mortgage statement or the actual mortgage offer that you received at the time of the application. So you'll be mindful of that. And I always say to my clients, plan 6 months ahead, because that gives us plenty of time to understand the options, and you're aware kind of your options at that point. So one last point on the reason why I mentioned 6 months. So if you consider the market right now, you can see how rates are shooting up, especially the Bank of England base rate as 1%. It might be a good idea to maybe lock in a deal 6 months prior to you trying to complete on a transaction. So what I mean by that is that when you do a new application, whether it's a remortgage application or you're doing a purchase application, a mortgage offer generally tends to be valid for 6 months. So give or take an additional month for the processing, valuation, underwriting and all that. Total all that to 7 months. It's probably a good idea to start the process a bit early, purely because of the fact that if rates are increasing, and they are, then obviously what you've obviously thought that you can get a week ago may not exist now. So what's the other bit I've mentioned there? Early repayment charges. So ERCs are early repayment charges. So be mindful that if you're looking to, let's say, do a transaction, you've got a cracking deal right now that you've seen, maybe a holiday home or something, or a nice cottage you want to buy somewhere, or anything, you may be tempted, if the early payment charges are quite low, maybe it's 1% or less, to break the existing deal and see if it's beneficial for you to do that and do a remortgage and then capital raise to be able to fund your next project. Again, it's just a thought, but again, you've got mortgage brokers and whoever you wish to speak to, if you've got your own brokers, to maybe try and work out the numbers to see whether that's practical. This is the other area I want to touch on, because there's a bit of misunderstanding in the market around what options are available when you get a buy-to-let mortgage. So obviously you're getting rental payments coming in. You can have an interest-only option or a repayment option. It doesn't mean that you always have to have an interest-only option. I've got a few clients that have taken a buy-to-let mortgage on a repayment basis. The other area I wanted to touch on briefly is that you now have options, including the normal 2-year, 5-year deal. You can have a 7-year and even a 10-year option. I've got clients now that are going for 7 and 10-year options because they just feel that it's better and safer to do that. They don't want to renew the deals after 5 years, after 2 years. So that those options do exist, and some of these options are quite attractive. Again, be very mindful before you decide on the options, because remember, you're tied in for that duration of period, so repayment charges apply if you decide to make changes to the loan or remortgage. So again, and it's always best to plan ahead, and I'm going to underline that whole word, planning ahead, and I'll tell you why I've mentioned the whole idea of planning ahead a bit later. EPC rating, quite crucial these days. The last 3 cases I've done, 2 out of the 3 cases I've done, literally at the point of finishing an application, rushing deals through. I had a rush case today, deals expiring tomorrow. Suddenly, lenders don't give us a lot of notice. Generally, it tends to be 24 hours or less. Sometimes you don't realize you've got a busy day, then you've got an announcement that lenders made, or you've got an email saying that rates are changing tomorrow, and lots of lenders do that. So I had to rush on a case today. I had to ensure the client was available on the phone for me to be able to process the application. It was done in a very smart way so that we bypassed the agreement principle. It went straight to application, so the rate was secured. Again, these are just some of the tricks of the trade, depending on how experienced you are, to try and ensure that you can secure the deal. Client's very happy, the deal's gone through, an agreement principle was done in the background by the lender. It was a buy-to-let application, and the deal's now secured. And this all happened within a space of 2 to 3 hours, and it was all done and dusted. Now, the reason why the EPC rating is very important is because what tends to happen sometimes, in 2 of my cases this week, literally, the client's existing EPC rating had EPC certificate had expired. Now, what you don't want to do is have that come up as an issue at the point of underwriting or any point during the process. So we've now done this, and we've now obviously put that as an additional check as part of a process to ensure that the EPC certificate is available. Same with ASTs, so that's your tenancy agreements that are in date and available, because otherwise that becomes a nightmare at the point of conveyancing when solicitors get involved. So it's important to ensure you're prepared. Well, it's good to check the register. There's an EPC register available online to check whether your EPC rating is between A to E. Because if it's above E, then it may be difficult to get a mortgage. If it's F, if it's A to C, then you may be able to attract better deals, which is why it's so important to ensure that you have the right updated EPC certificate available, because you may be able to get better deals, and which is why we keep on now talking about this subject, purely because of the fact that we can now get better deals on the market if your EPC rating is between A to C. That's the reason why that's there highlighted on my slide. Age of the applicant, again, it's an area that we come across a lot. So we get clients in the 70s have approached us to say, can I get a mortgage, remortgage, buy something together with my son, daughter? Yeah, by all means. I've got lenders happy to do that. Extend the term to age of 99. We've got lenders like that as well. So in the buy-to-let space, age is not a barrier, if I can maybe leave it at that. And then the other section that I wanted to talk about is any other income to support shortfall in rent. So what do I mean by that? We've got some lenders where if after evaluation the market rent of your subject property in question, which you're looking to remortgage, for instance, or purchase, is short in rent. So you say to us on an application that I think my property is worth, I think the rent that I can achieve on the market would be 1800, and that the market rent, which is the figure that the valuer puts down, let's say 1600, you've got a shortfall of 200. That would potentially normally mean that we may need to reduce the loan size. In some cases, for example, if we've taken a 2-year deal, we may be able to swap on a 5-year deal, and because of that swap on the deal, we may be able to get the full borrowing amount, because the lender's stress test might fit the shortfall that's come in. Or if you've got a very high income and low disposable income around available, because you've got less personal commitments, then the lenders may be able to use your income to support the shortfall in rent. Again, it's a very complex area. On a case by case basis, we can obviously look at that, but again, that exists in the market. I hope that's not been too confusing or too much for you to take in. Those are what I've discussed. Some of you may be aware of the areas I've talked about. So this is an area I'll touch on today, because we've not usually talked about this a lot, adverse credit. And I don't want to go into too much detail, but I want to highlight the areas that normally we come across from clients. So this is some complex areas that we sometimes do come across. So one of the things I've always mentioned earlier, or in many of my presentations, that there's a website called checkmyfile.com. It's always good to download that credit file, because it tells you your status of your credit, those are the data held with three different credit reference agencies. There's Experian, Equifax, and TransUnion. Most lenders would look at either 1, 2, or all 3 of these credit reference agencies, or even more. So you may want to maybe do that in the background if you're aware of any adverse credit maybe there, or if you have doubts before you decide to buy your first property, you want to just check how things are, then it's always the best practice to do that in the first place. The reason why it helps doing that is also it gives the broker a true reflection of kind of the data that's held for you with those credit reference agencies. So at the time of an application, there's no surprises at the point the underwriter picks up the case, because that's what they're looking at generally in the background in terms of the data they can see. And that's also quite helpful when you got lots of unsecured debts or lots of buy-to-let properties in the background. Again, it gives us the right information in terms of the start dates, loan amounts outstanding, term remaining, and so on. So why have I got adverse credit here? So this is really just to emphasize and just to make a point that if you're looking at a residential mortgage or a buy-to-let or a let-to-buy scenario, if you got situations where you got missed unsecured payments, so what do I mean by that? You've made a late payment on a credit card bill, or you're on a hire purchase agreement or a car finance agreement. So areas like that, you don't need to be too overly concerned, because we have lenders that they can take a view on things like that. Every lender's got their own criteria. Payday loans is another one that majority of the lenders aren't very keen on taking on a case like that where they can see payday loans, but we have quite a few lenders that are happy to sort of take on cases. I've seen criteria where if you've not had a payday loan in the last 12 months, then a lot of lenders are kind of happy to consider that. IVA is another one. Bankruptcy. So again, we can work with those clients and ensure that we can try and help them depending on what stage they're at. Mortgage arrears can happen. So during the COVID period, we've got lenders who have turned and said, we provided standard rates to this client because we understood the story, and we're happy to sort of sanction the mortgage. So again, not to be scared and worried or stressed about areas like that, because obviously there are lenders out there that can help. Credit score is another area. So why I put that in? Because it's good to just understand if you may have a small issue with your credit, it is how your credit scores been impacted, because there are some mainstream lenders that are quite fussy about credit scores, and so we want to make sure that we may be trying to avoid them at the time of an application if your credit score has been usually impacted. So anything below good, if it's a fair score, then again, just a bit of caution in the wind that we need to maybe relook at the whole scenario into the way we place the business. And CCJs can be quite common sometimes. It could be anything for a parking fine, which I've seen. If it's settled, then it works in your favor. So I thought these were the areas that would be nice to sort of cover off today as well, because there are lenders out there that can look at it. It's always good to plan ahead, which is why it's better to talk to the broker maybe 6, 7, 9 months before and say, look, this is my plan. What is it that I should be doing? How do I ensure that I meet the lender's criteria? And then we can work with you. So the reason why I mentioned about all planning ahead was because I looked at one of my reviews that I had recently, and I thought it'd be nice to share that. So this was a client that wanted to buy a house to live in. She was moving, and it was quite a complex case actually. I didn't realize until I obviously contacted a thorough fact find, and just to reiterate some of the things that she mentioned towards the end, and it basically finishes the Trustpilot review by saying, but in terms of long-term planning too. So this particular client obviously had other plans for the future. We then had to decide exactly the strategy in terms of the type of lender we went to, what our plans was in the future and retirement and so on. So it was quite important that those areas are covered off. So it was a case that took a bit of a while before we placed it, because the client's circumstances were changing. They hadn't applied for a mortgage for quite a while, and it just required a bit of common sense approach, understanding what their long-term strategy was, which is why it's interesting that she's actually finished off the Trustpilot review using those words. So if you're wondering in terms of my areas of expertise and what I'm experienced in looking at, so apart from bridge finance lending, commercial development finance, second charge, portfolio lending, residential lending, personal business protection, basically any type of finance where there's an asset in the background, including third charge lending if required, is possible. So we do have clients sometimes that need short-term finance because they want to raise a bit of capital. They're short by 20-30 grand, and there's various quirky ways of raising cash without having any repayment charges as well. So lots of different ways of raising cash as long as there's asset in the background. You've got my details here on the right hand side, and what I wanted to finish off really was to talk to you about an event we're having organized by ourselves next Thursday. And so I thought it'd be nice to reiterate about that event. It's a week away. Tickets are still available. So it's called Educating Property Investing Conferences. So it's a event that's highlighting more around educating our clients and just making them aware of kind of what lenders are looking for in terms of different areas. And also it's an event we decided to organize because I think we found previously 2-3 years ago when we had done events like this, especially when the managing director, who was by himself at that point, we're now a group of 8, he found that it was very, very useful, and I think we had some great feedback, and we were lucky this time around that we have at least I think 8 odd lenders coming in, and we touching on various topics. We also have, apart from ourselves, Sotera Planning, who sort of have an office in the same building where we're at, and somebody called Jamie is going to be coming down there and talking about wills and trust and areas like that. Avocado Property, who we work with very closely, are an estate agency. In terms of specialist lenders, so we've got the agenda and all that listed now. Anyway, in terms of who's coming and what the agenda is for the day, but these are the areas of topics that we're covering. So bridging, buy-to-let, development finance, refurbishment, so the BRR area, commercial mortgages as well. And if you're wondering in terms of the timing and where to get your tickets, so the tickets are £10. You can get it via Eventbrite. That's the address there, and it's on the 12th of May between 11 to 5, and it's at um, Gerrard's Cross. I forget the place actually. Give me 1 second. It's called. So, yeah, it's a Crown Plaza. That's where it's at. So if you link up with me on LinkedIn or Facebook, I'll be posting obviously the venue information again, and also details of how to get there. So we've got a post that we've created today, so that's going to go on this evening as well. But yeah, if you got any questions, then let me know. I know there's somebody else after me, so I'll stop now.
Right, Mitesh, very good, very useful. Can we have our screen back, please? Oh, is it Surinder? Am I mucked something up? Right. So stay there, don't disappear. And look, I told you you should have it on YouTube and Zoom meetings. That way you wouldn't have to find the address, right? So anyway, I'm gonna have to take that off. Right, okay. Very interesting. And I guess there's some pain coming from Mr. 11. Mr. Number 11 wishes. So, one formal change to another. We've got the leaseholder format going on. Really interesting subject. And guess what? Got a super expert on the subject to give us next talk. So, well, give him a standing ovation. No, don't worry about the standing ovation, right? I just thought I'd put that in. But look. Get your, where's my, I've thrown away my colouring pencil. There you go. It's my colouring. Get rid of that. Get your pens out. Get your notebooks out. Take some good notes. Because I've seen this guy speak a lot. I was going to say something rude there in a minute. He knows his stuff. So, Bernie, over to you, sir. And I don't know what you're going to ask me next. Yes, you can. Surinder's put the £50 notes in. I hope you can share your slides. So, over to you, sir. Yeah, I think you're still muted, by the way, Bernie. Bernie, you're still...
Yeah. Better? Is that better?
Much better. Surinder obviously didn't put enough £50 notes in the machine, so away you go, sir, and I'll try and stay quiet as long as I can, but it's might be difficult. For the audience, please put your questions in the chat. We're going to get our money's worth out of Bernie today, so off you go, Bernie.
Okay, thank you very much for that nice introduction. The subject of my short talk tonight is how will a short leaseholder benefit from the new leasehold reforms? Bit about me, those who don't know me, there's some boring information about me. I've been a hands-on property manager for more than 40 years. I'm also a leaseholder, several leaseholders actually. Resident company director several times over, company secretary hundreds of times over, freeholder of blocks of flats, don't know how many of those I've done over the years, investor, trainer, consultant, etc. You can find out all the boring information about me at berniewales.co.uk. So, going back to our subject for tonight, I think really it's probably worth starting by defining, well, what is a short lease? I get various answers to that when I'm presenting to an audience face-to-face, ranging from 90 years, 70 years, 60 years, 12 years, etc. The truth is really that short leases don't exist. They are long leases that have been worn away by time. And short lease is really a nickname for those longer leases that have a short unexpired term. And we're talking there of sort of 70, 60 years unexpired or below. But there are other trigger points in the length of a lease which you should bear in mind, and the principal one is 80 years unexpired, and we'll cover a little bit about that later on. Now, there are various leasehold reforms that are heading our way. The government has proposed a whole raft of changes. Broadly, they are leaseholder friendly as opposed to freeholder friendly. The Law Commission did an enormous report on leasehold and also common hold and published that back in 2021. And there are all sorts of proposals which I will come on to later. But only one bit of legislation has actually reached the finishing line and has had Queen Elizabeth's signature, and that is the Leasehold Reform (brackets Ground Rents close brackets) Act 2022. Came about, I think it was February, it arrived, and the statutory instrument implementing it came in just recently, stating that it becomes effective from 30th of June 2022. What does that act do? Well, it states that all new leases that are implemented, completed from 30th of June will have to have a peppercorn ground rent, a zero ground rent. And the main reason for that is to get rid of what started off the leasehold scandal of a few years back, where major house developers were selling houses via leases, and they had onerous ground rent terms in them, for example, doubling every 5 years. Those sorts of ground rent clauses caused immense outrage and really prompted the government to move forward fairly quickly with these particular leasehold reforms. Now, in addition to new leases that are completed, this will also apply to lease extensions, which you would need if you have a short lease and you're looking to sell or you're looking to refinance. Your lease extension, whether it is a statutory lease extension or an informal lease extension that you discuss and agree with your landlord, must have a zero ground rent. Let me clarify that a little bit further on those extensions. The extension must have the zero ground rent. Existing ground rent can continue under certain circumstances, but the existing term and the existing ground rent usually would continue. You can discuss that with your landlord and can come to an arrangement whereby that could be removed so that you have no ground rent to pay going forward. But in terms of the law, it is the extension bit that must be zero. Now, there are other leasehold reform proposals, and I'll briefly go through those. So far as statutory lease extensions is concerned, there is a proposal that the present additional 90 years will be changed to 990 years virtual freehold. Now, the government hasn't stated as to whether that additional 900 years will be free. I very much doubt it. You'll be entitled to that longer period of time, but you'll probably have to pay for that additional 900 years. But that additional 900 bit is at least 90 years away, and therefore the present day value of that future extension is pretty small. Certainly small in comparison to the 90 years from the end of your current term. So I wouldn't get too worried about the cost of that additional 900 bit. One of the other proposals is to abolish marriage value. Now, I won't go into the boring definition of marriage value, but it's part of the lease extension calculations. It's part of the right to enfranchise freehold buying calculations. And it's where you look at the leaseholder's interest in the lease prior to extension and after extension. And you also look into the value from the freeholder's point of view prior to extension and after extension. And there is a methodology of dealing with those positions called marriage value. And certainly once you get below 80 years, then marriage value kicks into the equation. If you have an unexpired term more than 80 years, marriage value is already ignored. But once you hit that 80-year mark, marriage value kicks in and your lease extension premium is more, costs you more. The nearer you get to zero, so 70 years, 60 years, etc., that marriage value becomes very important and very costly from a leaseholder point of view. And that is why I think that there has been this proposal to abolish it. Now, I don't think that that is going to arrive on the statute books without a fight. The big PLC freeholders, if marriage value is abolished, then billions, literally billions, will be wiped off their balance sheets. So I suspect that that will have legal challenge. I suspect it will go all the way to the Supreme Court. And there's going to be a lot of argument about that, particularly as there are some big freeholders sitting in the House of Lords. There's also going to be, apparently, a change to the formula for enfranchisement valuations and lease extensions. They haven't told us what those changes to the formula might be. I suspect that they will tinker with deferment rates and yield rates, etc., but they haven't specified what that might be. And I have no doubt there will be some interesting discussions about changes to those various rates, or what other changes they want to do to the formula. The government has also proposed that there will be an online, an official leasehold extension calculator and a freehold valuation tool. There is already an online calculator that is provided via the lease website, the Leasehold Advisory Service website, but it appears that there's going to be what you might term an official calculator, an official valuation tool online, which will reflect the changes. We have no idea when that is likely to arrive, and I suspect it's going to be some time after they've decided what changes in the formula there might be. So that's not going to be tomorrow. Other changes include changing the right to enfranchise, qualifying criteria. That's where leaseholders force a freeholder to sell the freehold of their building under certain circumstances. And also changes are proposed for right to manage, where leaseholders can force taking over the management of the building from their freeholder. One of the main changes is going to be a change in the percentage for the non-residential internal floor area. So where you have for example, a ground floor shop with flats above, presently, if the commercial internal floor area is more than 25% of the total internal floor area of the building, then the leaseholders don't qualify, or rather the building doesn't qualify for right to enfranchise or right to manage. The proposal appears to be changing from 25% to 50%, which will mean that many more flats above shops will come into the scope of right to manage, and leaseholders will also be able to buy their freehold, probably with a lease back of the commercial to the freeholder, because generally the freeholder is interested in the commercial rent from the shop rather than the aggravation of the residential bit upstairs. When will all of this arrive? Well, if we have a look at the one bit that has arrived, the Ground Rents Act, that first crossed the parliamentary start line, so to speak, about 5 years ago. And it is only just now reaching the parliamentary finish line. So it's quite a long process. And that act was with all-party parliamentary support. Everybody wanted it to happen. So in 5 years. Don't exactly do things quickly in Parliament, do they? Now, none of those other proposals that I've just briefly gone through have got to the start line yet. And therefore, I doubt very much that they are going to be with us tomorrow or any day soon, particularly those that are contentious and are going to have debate or legal challenges along the way. So they're nice things to look forward to, but they're not going to be here tomorrow. So I would advise you to, if you certainly need a lease extension, if you're in the 80-something area, then get on with your lease extension. If you are in the, I don't know, 90 years or above, then possibly you could wait and see what happens over the next few years. But obviously, every day you delay, the cost of your extension increases. If you are below 80 years, then marriage value already applies to you. And therefore, I would say probably get on with it. If you're just over the 80-year mark, at 79 years or whatever, then possibly you could wait to see if it is abolished. But I personally wouldn't recommend doing that. So the short answer to when is not yet. Now, briefly, before I go on to questions, if you're interested in leasehold and all topics leasehold, I have got a Leasehold Lessons live training course coming up. By live, I mean it's not a recorded one. It is one where I will be like this, talking to the trainees via Zoom. There are 30 topics covered in the training course. It is starting on the 16th of May. They are evening classes, 6 p.m. to 8 p.m. over 10 nights, Monday to Friday 1 week, Monday to Friday the next week. It is being recorded, and those recordings are available for the trainees. So if you can't make one particular night, you can watch it the next day or in the next few days and catch up. Further details on my website, berniewales.co.uk. Click on the shop tab and you'll find all the information there. There's the shameless plug. Now, questions. Let's see what questions you've put into the chat box, and I'll go through those one by one. If I can work out how the hell I stop sharing, have a look at the chat, and we'll see what we've got. A formal calculator, if binding on both parties, would get rid of all of the hassle over agreeing the price, even if nothing changes. Thank you for that, Colin. I think it will provide a guide, an official guide as to what the proper value should be. If the calculator reflects changes to the valuation formula that are mandatory, i.e. you must use this particular yield rate or this particular deferment rate, then I agree that the calculator will provide a price, and that price can't be argued with. However, I think it will probably be on the basis that this is a guide and is a generic thing, and the leaseholder and the freeholder, or rather their valuers, will be at liberty to discuss the specifics of any particular flat, any particular building. Is there hope value, development value, all sorts of things that valuers love to argue about for months on end, I think all of that might come along. But certainly, if there is an official calculator that provides an accurate official figure, I think that would be good in getting rid of a lot of the arguing. Do we have any other questions? Or, if I'm at liberty to say, unmute yourself and ask away.
Oh, no, don't do that, Bernie. Don't let them ask their own questions. Chaos. Right. I've got a couple of questions. It's a fascinating subject for me, actually. So currently the process is you send a notice to the freeholder. There's some sort of time period to respond. I forget, is it 21 days or something? And if they don't respond, it's deemed that your offer is accepted. However, if they respond, then the argument starts with the surveyors, and inevitably, I think the leaseholders end up paying for the surveyor's costs. Have I got that right? So
yes, the present arrangement is certainly the statutory lease extension. A leaseholder can serve a Section 42 notice upon the freeholder, provided they have owned the lease for 2 years. That's another proposal that might change, that if you own the lease, you can serve a notice the next day. You serve your notice on the freeholder. They have a period of 2 months to respond. They either reject your claim or they accept your claim and say, yes, that price is fine, or they accept your claim but say, actually, the price isn't fine. I think it should be twice as much. And then the valuers discuss and swap notes, etc., and come up with, hopefully, a mutually disagreeable figure somewhere in the middle of those 2 points. If the valuers can't agree, then the leaseholder can apply to the not the leasehold valuation, yes, the leasehold valuation tribunal if you are in Wales. It is the first tier tribunal brackets property chamber, close brackets, if you are in England, and you apply to them for them to make a determination as to the correct valuation figure. Normally a paperwork exercise, both sides will send in their calculations and formula. The FTT will look at that and come back with a determination, normally fairly quickly, 4 weeks. That process, as I say, may change. It may certainly all of the changes that are proposed are leaseholder friendly. There is the possibility that the costs which the leaseholder is required to pay for the statutory process, those costs may be capped. At the minute, they have to be reasonable, and reasonable is one of those words that makes lawyers money, because what I think is reasonable, what you think is reasonable, and what the freeholder thinks is reasonable is all different things. There are boundaries, I suppose, and normalities of sort of £1,500 to £2,000, but there are circumstances where actually things are much more complicated and therefore fees can be higher. Reasonable has to relate to the circumstances, I would say. But if those costs were capped at a particular figure, that is probably a good idea, provided that is updated from time to time, or index linked or something like that. We have a situation elsewhere in leasehold with major works where a consultation has to be had with the leaseholders if the cost for any one leaseholder is going to be £250 or more. Now that figure was set a long time ago. I can't remember exactly when, but probably 20 years ago now, when £250 was quite a reasonable amount of money. These days, it buys you just a little bit more than a vanilla latte. So it's never been upped. And, you're ending up consulting on, an awkward to get to light bulb or something like that. It's not quite right. So I think if reasonable costs are to be capped, then it would be wise for the government to index link that in some way so that valuers get paid a reasonable fee and lawyers get paid a reasonable fee 10 years, 20 years down the line. We shall see.
Yeah, that term reasonable crops up everywhere. And like you said, it makes lawyers a ton of money.
Sure does.
Sorry?
It sure does, yeah. Well, and me every now and again.
And you, okay, all right. Well, that's all right. We can let you get away with it. And I'm not going to ask where you buy your lattes from, but I'm guessing other brands are available. Just looking at I'm looking at your website and really interesting layout you've got there. So am I right in thinking you're going to do these over, is it 2 weeks?
That's right. The leasehold lessons are over 2 weeks, Monday to Friday, starting the 16th of May, 6 p.m. to 8 p.m. The finish time obviously depends upon the Q&A at the end of it. Normally it's an hour to an hour and a half of me rabbiting on with the training and the information, and then questions thereafter related to those subjects. We do 3 subjects per session, and there are 30 subjects in all. We record them, put them on the resources page together with the downloads and various bits of documentation and things that are useful on the relevant subjects. Put that link, the recording link, onto the resources page so that the trainees can look at that and recap, or if they can't make a particular evening, then they can catch up the next day or in the next few days on those particular subjects. We did do it previously in the afternoon, and that was fine for people that weren't working, but obviously a lot of people are working 9 to 5, so evening classes this time round seemed to be the logical thing to do.
Evening classes, that's the term I haven't heard in a while, yeah? I'm guessing, I'm just looking at the website, the prices are quite a small teaspoon of that latte that costs 250.
Indeed, yes. The live ones cost £60 per person, which is peanuts, frankly, for the amount of information and education there is. But it's designed for leaseholders primarily and making it affordable for them. Leaseholders are always complaining that everything is expensive and they can't afford anything training-wise because their freeholder has already bled them dry by taking all the service charges, etc. So it is done at a very low price, but you know, if I've got, well, on the last one I did live, I had 80 people sign up. So, you know, that adds up to enough to keep me in latte for the 2 weeks.
Okay, so all they're doing is buying you bits of latte so you can keep going. Yeah. So no, it's a great idea actually. Obviously, I can't comment whether I'll be coming or not, but you can take a hint there. Out of all the subjects you're going to discuss, what do you think is the one key secret that people are not aware of but should be aware of? Like a magic tip there.
The magic tip, it's an old tip of mine, but I provide a consultation service and people pay money to ask me a leasehold question. They sometimes send me a whole load of documentation in addition to their lease. And I would say at least 95 times out of 100, if they read the bloody lease before booking up the consultation, they don't need the consultation. The lease is the rule book for that particular flat, for the running of that particular building, for the service charges, etc., etc. And yes, sometimes it's written in legal gobbledygook, but not always. And certainly if you try and read it, and then when you wake up, you finish reading it, and you know, quite often you can find the bit of information that you need. But I would say try that first. Read your well. Number one thing is find the lease. So many people book up a consultation with me. I say send me the lease, and they say, "Oh, I can't find that." You should get your lease for your flat. You should have a look at it. Number one thing is how long is the lease term? 99 years from whenever, 125 years from whenever. And therefore, how many years left have you got? Well, not you got. How many years left has the lease got?
Careful there. Careful how we say that. That might shock a few people into waking up.
If we knew how long we got, we'd be able to make some really good property investments, wouldn't we?
Yeah.
No, find out how many years unexpired there is on the term. That is really useful. Find out what your service charge proportion is, etc. If you can't understand your lease, then I do offer a lease reading service as well. But that is the number one tip. Read the bloody lease. It is so obvious. It really is.
Surinder, we should title this show "Read the Bloody Lease." in Michael Caine quotes. Buddy, you can't do an impression of Michael Caine, can you?
You're only supposed to blow the bloody doors off.
Yeah. Just say, read the bloody lease. Okay, anyway. Yeah, exactly. You got it in one. So that's actually a very good tip. So, yeah, and a lot of people shy away. I guess the second tip you've wrapped in there is do it in chunks, when you fall asleep.
Yeah, do it bit by bit. And obviously there is landlord and tenant law. There's a lot of it out there, and case law and stuff like that. And that's why there are 30 subjects covered by the leasehold lessons, because it is quite a varied subject area. I suppose the other tip would be, just because a managing agent or a landlord sends you a bill doesn't mean you have to pay it.
Yeah.
There's a whole load. Actually, a legal service charge demand is required to have a summary of rights and obligations attached to it. And in short, that is a whole load of reasons why you shouldn't pay. They're required to send you all the reasons why you shouldn't pay. So maybe start with reading that. If you don't understand any of that, don't automatically pay. Check that you are being asked to pay the right amount on the right day of the year, etc., etc. So there are lots and lots of reasons why you shouldn't pay a service charge demand, quite apart from the occasional things like the landlord spent the money on the wrong thing, and it's not actually allowed under the terms of the lease. But, if nothing else, when you get a service charge demand, read that summary, and that will give you clues as to why you shouldn't pay.
We're developing a theme here. Read the bloody lease, read the bloody summary, I think.
Definitely, yeah. There are so many leaseholders out there that just pay up. And, it's not necessarily the thing to do. You need to make sure, particularly buy-to-let landlords, what you're spending on service charges is coming out of your bottom line profit. And therefore, you don't want to spend more on service charges than you have to. So just make sure that what you are being asked to pay is the right thing, and pay what you are legitimately, legally required to pay. I'm not saying don't pay and never pay, but make sure you're paying the right thing at the right time, in the right way, etc.
And use the rest of the money that they save to buy you that golden latte. Yeah?
Sounds good. Sounds good to me.
Right. Surinder, have you got any questions before we sort of lose the plot completely?
Well, you mentioned something of what is due to come, the extension of lease from 90 to 990 years. And you also said that there would be a charge. What, in your opinion, do you think would that be? As you said, that the value of the lease is not all that.
When you get a lease extension, the premium is designed to compensate the landlord for principally two things. One is ground rent is going to disappear for that extension. They're not going to get it going forward.
Yeah.
So that's one thing. That's a straightforward, in a way, mathematical calculation. The other thing that you're compensating them for is vacant possession of the flat at the end of the lease term. Now, if that is, I don't know, 50 years away, the value of, let's say, a £250,000 flat 50 years away may be 25,000 or something like that. Think of it as how much would the landlord have to put into the bank or building society so that over the rest of that lease term, it makes £250,000 if that's the value of the flat.
Mm-hmm.
If that's going to move away from 50 years to 900 and something,
Mm-hmm.
then you have to put less into the bank or building society to build up to that figure because it's a long, long, long way away. So the present day value of that future vacant possession is less. So the first bit that you pay, the present 90 years, that's closer to now, and therefore that's the expensive bit. The bit that's beyond that is far less expensive. I'm trying to explain this in non-valuation ways. And therefore, I don't think that 900 is going to be that expensive, relatively. But I don't think you're going to get it for free. Why should you get it for free? You know, it is worth something, and therefore the landlord should be compensated for that. The whole reason for this and getting rid of ground rent and changing lease extensions so that they are effectively a virtual freehold is because the government's, in fact, there's all party support for the alternative to leasehold, which is common hold. Now that came in with the 2002 Act, the Common Hold and Leasehold Reform Act 2002, but didn't take hold. I think there are something like 12 or 13 common hold sites across England since 2002. It just hasn't gone there. And why would a developer create a common hold development as opposed to a leasehold development where there's ground rent and therefore they can sell that freehold thereafter with a ground rent? You know, they have been making money out of that. And that's how the leasehold scandal developed, because Taylor Wimpey and other big developers were selling these leasehold sites immediately after they completed the development. They were selling them to investors for a lot of money. The government wants to get away from that and have a situation where leasehold isn't profitable from that point of view. You know, you can't sell a freehold for a shed load of money. And therefore, it will be far more equivalent to common hold, where the individual flats, the units as they are called in common hold, will be owned in perpetuity, what you might call freehold flats, but they'll be common hold units. They won't have this depreciating asset of a lease that gets shorter and shorter. In theory, at the end of that lease, you give the whole flat back and walk away. You won't have that situation. Now, that's where the government is heading. They want to get rid of leasehold. They can't just abolish it overnight and put in common hold. Common hold, as the law stands, is not perfect. It needs some tweaking. But that's where they're heading. They want it to be the preferred alternative. And I suspect that over the next 2 generations or so, leasehold will gradually disappear and common hold will gradually take over. That's my prediction. I won't be here to see the end of that, and probably you guys won't either. But our children and grandchildren will probably be living in common hold units rather than leasehold flats.
Eddie,
Yep.
you mentioned there's some very large freehold owners in the House of Lords. Can you spill the beans and name them?
There's quite a lot of MPs and lords on both sides of the House who have interests in property. I mean, Keir Starmer, head of the Labour Party, is renowned for having property, etc. So
No way, no way.
yeah, you have a look. It's not just the Conservatives, etc., etc. There's a lot of them, but big developers, big freehold companies, pension funds in particular, all have big interests in freeholds and freehold ground rents, because ground rent is a relatively small sum of money that is payable every year. It's pretty damned predictable for a long time. And that's what pension funds like. That's what big property companies like. It's predictable income. And if that is affected in some way, for example, by abolishing marriage value, then the value of those freeholds will be slashed dramatically. And therefore, I think there's going to be a fight down that road. It's not going to be easy to get down there. That would be leaseholder friendly to the nth degree. And the other side of that, I suppose, from a freeholder point of view, is would it be right for the government to interfere in existing contracts retrospectively? I think that would be undemocratic, probably touches on human rights, and it's something that is likely to go to the Supreme Court. So I don't think that will get it in onto the statute books in a hurry, if at all. I think that what is more likely to happen is that the government will do as it has done with ground rents. It will say from a particular date, you must do common hold, or something like that. And therefore, leasehold will become more and more the old system and will gradually disappear. And alongside that, if right to enfranchise becomes easier, then groups of leaseholders will gradually buy their blocks of flats, buy the freeholds, and gradually the big freehold owning companies, their portfolios will get smaller and smaller and eventually disappear. That's what I think will happen, but it's not going to affect you and me while we're still working and investing and trying to earn a crust.
But we talked about freehold flats. Now, there was some years ago the scandal of freehold houses.
You mean leasehold houses?
Leasehold houses, yes. The big builders, and it appeared that the ground rent was doubling every 5 years instead of or less, and they started off at £1,000. So in say 20 years' time, the ground rent would have been greater than the mortgage payment.
In some cases, greater than the value of the house. Yes,
yeah.
Indeed. That's what kicked off the scandal. Now, the government, and in particular Michael Gove, as Housing Minister, Secretary of State, has been putting pressure on those developers, the big developers, both on that front, don't create leasehold houses unless there is a very good legal reason for doing so. It's part of a particular estate or something like that where there are proper legal reasons for requiring leasehold. And if you are going to have leasehold, then it's got to be 999 years, a virtual freehold. Don't create them unless there is an absolute need to do so. And the other side of what Michael Gove is doing is putting pressure on those developers in terms of cladding. And, you're going to pay for all of that bad building that has gone on over the last 30 years. And that's good for leaseholders that is being put right. I mean, there are hundreds of thousands of leaseholders who presently have got blighted flats, and they've still got a problem now. And that's not going to be solved overnight, because there aren't enough scaffolders to put up the scaffolding. There aren't enough cladders to do the cladding, even if the materials are there. So that's going to take a good few years to sort out. But the bigger problem that's coming down the line is not cladding, it is compartmentation. The building safety bill that's going through Parliament at the minute, which will become the Building Safety Act, which has sort of flowed from Grenfell, etc., is looking at not just cladding and stuff like that, but the general safety of leasehold flats and buildings. And a lot of them, almost every single building you look at, has had holes drilled in the walls to put wires through, pipes through from flat to flat, etc., etc. And if pipes and wires can go through those holes, smoke and fire can go through those holes. And therefore, the compartmentation is breached. In theory, buildings are built so that if there's a fire in one flat, it can't get to another part of the building. But you go and have a look at, I would challenge you, go and have a look at any block of flats. You will find somewhere where that fire can get through from one bit to another bit. And that's all got to be sorted out over the next few years. And that is going to cost a lot of money for all leaseholders. So that's going to be the bigger problem.
Well,
Alongside of that, we've also got buildings insurance premiums going up, because the buildings insurers have realized that actually, yes, cladding is a problem. But frankly, when we have a look at these blocks of flats, they're all a problem. And it's costly and therefore more risky than we thought. And therefore, the premium has got to go up. And Brexit has made materials more expensive, labor more scarce, etc. So getting the work done is more expensive, and therefore buildings insurance premiums go up even more. So it's not very nice days for leaseholders at the minute. And certainly over the next 10 years, whilst these reforms are coming along and they will be leaseholder friendly, at the minute, there's a whole load of stuff that is going to make leaseholders safer, but it's going to cost them.
Now, the compartmentalization doesn't apply to the big flats, big blocks of flats. It also applies to the conversions. Most of the conversions do not have compartmentalization.
Yes, but I still challenge you to look at any block of flats and you will find breaches of that compartmentation. I was looking at the landlord services and where the meters were, and there was a meter cupboard on each floor.
Right.
And if you look down, you could look from the top floor to the bottom floor.
Sure.
So fire can get through from the bottom floor to the top floor, you know, and that's on a brand new block that is supposed to be compliant with building regulations. Clearly wasn't.
Yeah. Sure. That also can happen with the refuge chutes.
Yeah, definitely. I mean, certainly converted flats, you know, converted Victorian houses or something like that is probably a worse situation and more likely to have those troubles. But all of those problems have now got to be researched, assessed, and corrected over the next few years. And you'll see property managers delivering an unwelcome message as that gets looked into and costs are going to be incurred. It's all for making people safer, but it costs money.
Sure, it costs money, but it was initially negligent building and inspection which led to it.
Yes, I agree. And certainly when we haven't got to the end of the Grenfell inquiry yet, but there's a whole load of things that were wrong there. You know, stay put was not a good idea. Only one staircase out of the building was not a good idea. Having a gas main running up that one staircase was definitely not a good idea. There's a whole load of things that were wrong there. But Certainly things are improving. Certainly developers are going to have to build safer buildings, and those buildings are going to be inspected, I think, more rigorously, because there's going to be, you know, building safety managers and things like that who are going to be held personally liable if safety is breached, and therefore people will actually look at those services that go from top and bottom and make sure that actually they are compartmentation safe.
Bernie, we talked about, Surinder talked about Victorian houses that were converted, or it might have been yourself. Surely that's a different aspect because they're only 2 or 3 stories high. Whereas if you've got a block of flats, say Grenfell, that's at a level where people can't get off, you know, where you've got a 2-story high building or a 3-story.
Yes, I agree with that. That yes, if I think it's probably something like 7 stories and above, isn't it? Where the fire brigade haven't got a ladder that's long enough to get to you. But the majority of people that die in fires die from smoke rather than the flames. But yes, if you wake up and notice that there is smoke, then yes, if you're in a Victorian 1st floor flat or 2nd floor flat, you could, in theory, jump out the window if you really, really needed to. Can't do that if you're on the 20th floor, I suppose. But the chances are that actually you won't wake up because the smoke will have got you before you wake up. So I would say Victorian conversions are equally dangerous to higher rise stuff, you know?
Yeah, and luckily we've got smoke and fire technology and so on and so forth. But look, this has been a really interesting subject. I'm going to say have a look at your website and have a look. Surinder, can we put a link on our YouTube and the Facebook channel so we can guide them?
Sure, we will do on under the notes. Yeah.
Yeah, Buddy, is there a limit to the number of people you can handle, or have you got?
Basically, with Zoom, I think you can have 100 or 500 or something, can't you?
Yeah.
If I had 500 Q&As, that would be a bit tricky. Certainly, we were able to cope with 80 on the last one. But I think really from a practical point of view, anything up to 100 is probably okay. Because bear in mind that whilst people can be educated in a generic way, and I can tell them about how to read the lease and what landlord and tenant law is and stuff like that, I can teach generically. All the questions tend to come back as bespoke, you know, my flat or my block or something like that. And so it's difficult to answer those ones. I've got to come up with answering a bespoke question in a generic way so that everybody can benefit from that. So up to 100 is probably okay. Hopefully I can explain things in a simple enough fashion so that there aren't too many complicated questions, but everybody looks at it with their block of flats in mind, and that always sparks questions. It always does. But we'll get through it. If everybody here books up, I'm quite happy with that. That would be wonderful.
Yeah. So, and I usually don't say this, but I would say go and book up. It's like, you know, a couple of teaspoons of latte in your case, but for the rest of us mortals, it might be latte for a week. So yeah, go for it. You know, and I've seen a lot of your stuff on YouTube, so you do know your stuff.
Thank you.
Not that I'm an expert on leases, but you know, it's some of the tips you give are fantastic. So so please book up. Go for it. And do you have a refund policy?
Yes. I think I've said on some of the adverts I put out that if you don't save more than the course fee, I'll give you your money back. If somebody's not happy, you know, as we're going through the course, I would give them their money back. You know, it rarely happens.
Yeah.
But, you know, if somebody's not happy, I'll give them the money back. You know, it's not the end of the world. You know. There
you go. The money back guarantee. Maybe that's what you. So no, it's just that people say, "Oh, I've got to do a course and so on," but you know, it's fantastic. I mean, I'm just looking through. I'm cheating. I've got two screens here. I'm looking at some of the stuff you're going through. I haven't got any arguments on it. So fantastic. Look, it's been really informative. I've got one more question, actually, if you don't mind me asking.
Yeah.
So you said this new stuff applies post 30th of June 22.
Yes.
What happens to the leases before that? Is that still in flux?
No, that stays the same. They're not doing anything retrospective. So if you have an existing lease with ground rent, then that continues for that original lease term. If you extend, then that extension bit will have to be peppercorn ground rent, i.e. zero ground rent, irrespective of whether you go down the statutory route or the informal agreed route. Now, you could, with discussion with your landlord, agree that the present existing term ground rent is wiped out as well. They probably want compensating for that. But again, that would have to be reasonable. And I suspect that's probably the way that most freeholders will go, because they'd rather have, an extra £1,000 or £2,000 now, rather than £200 a year for a while, So I suspect that's what's going to happen. But so far as the law applying is concerned, it deals with new leases, whatever they are, from the 30th of June, and extensions from the 30th of June.
Okay, great.
All right.
Yeah, no, fantastic.
Finally, one more question.
No, Surinder, you got to put more money in the meter, mate. You can't have questions.
You said to me before that I've put the £50 in instead of the 50p.
All right, let you off. You could have an extra one. Come on.
If you have extended a lease once, can you go back a few years later and extend it again?
Yep, you can go back the next day and extend it again. Yes, I mean, presently, a statutory lease extension will give you an additional 90 years.
Right.
So your old 99-year lease from whenever it was becomes 189 years from whenever it was, etc. So you can move that forward. You could then do another statutory notice and get another 90 years. Wouldn't cost you very much for that, because it's at the end of that 189 years. What's the present day value of that bit? Not a lot.
Mm-hmm.
Depends on the interest rate, doesn't it?
It does. The yield rate, the deferment rate, etc. All of that has an effect. The further away that period is, the less of a bottom line effect that is. And certainly, going back to our original topic of short leases, the nearer you are to zero, the more that those rates have an effect. If you're down at 60 years or something like that, and you tweak a yield rate by 0.5%, that has a really big effect on the bottom line. It really does. And the same with the deferment rate. So the nearer you get to zero, the worse those little tweaks are in terms of what you pay.
So in theory, you could, instead of statutory, you could get an agreed extension of more than 90 years if the landlord is
yes, the landlord certainly. I mean, a lease is a contract between two people. So if both of those people agree, then they can extend that for 999 years. And quite a lot of freeholders will do that with you. It's not down the statutory route. That's just an agreed lease extension. So yes, ask the freeholder. If you don't ask, you won't get. If you do ask, you might. You never know.
So when people are going down the statutory route, they could also say, okay, fine.
Yeah, just because you've served notice doesn't mean you can't discuss with your freeholder.
Mm-hmm. Fine.
Happy?
That's it.
Bernie, I'd love to carry on talking with you, discussing this subject. It's super interesting and definitely the right chap for it. Will you be giving any tips for potential investors on this program, or is that a different one?
Certainly buy-to-let landlords are considered in this. I mean, it's catered for primarily leaseholders, whether they are occupational or buy-to-let. It also covers it from a property manager point of view, and to a degree from a freeholder point of view, and certainly from a resident freeholder point of view. So where residents have clubbed together and bought their freehold, quite often they get themselves into all sorts of bother because they don't understand what the hell they're doing.
Yeah.
And so we cover that sort of side as well. But I'm always open to suggestions. If there's something I'm not covering, then let me know and I will try and cover it.
Great. Thank you.
Absolutely fantastic. So, look, when do you think we should have you back on, Bernie? Because this, I guess, this is a continuous live subject.
It is, yes. I suppose probably the best thing to do is subscribe to my newsletters, where I deal with all sorts of leasehold subjects, and in particular, the changes that are coming along. So if anything of those grabs your interest from your side of the fence, so to speak, then ping me a note and I'll gladly come back.
Fantastic. So, Surinder, we watch the newsletters and then let's get Bernie back on, because I guess this is a subject that runs and runs, and just like this, it carries on running, doesn't it? And as you said, blame William the Conqueror for this on your website.
Indeed.
No, but
Right. Thank you very much for having me on. It's been a pleasure.
thank you. No, thank you for your time. We look forward to, well, I'll definitely be coming on. Everybody else make up their own minds. This is not a recommendation, because I'm probably not allowed to recommend, but you go for it. All right. So, Bernie, thank you very much. We look forward to having you on again. To all the rest of our viewers, hope you found that really interesting. And of course, your favorite property show will be back next week, same time, Thursday, 5 p.m. Look forward to it.
Good stuff.
Surinder, can you make sure we switch off this time and not do a 24-hour live cast? Surinder, are you still there? Wakey, wakey.
Okay. Bye.
I'm here. Bye,
you.
Bernie. Thank you very much indeed.
Right.
Mitesh. Any questions for Mitesh?
No, I'm okay. I'm happy. Yeah.
Yeah, okay. All right.
Well,
Okay, then.
you look happy, Mitesh. So it's right. That can't be bad. Must be a great show. Mitesh is happy today. Happy days. Obviously, he's happy his mates put the rates up. Anyway,
No,
Okay.
I'm happy because I've had a completion
Yep.
in good time. So
right.
Thanks for your presentation too.
Right. Are we still live?